on implementing DPDPB 2022, that is Digital Personal Data Protection Bill, powered by AmbiSure Technology in association with CXO Junction. For this, we have an eminent speaker and our amazing moderator, who is Mrs. Khushbu Jain, who is a practicing advocate before the Supreme Court of India and founding partner ARC Legal. She is executive board member of ACFCS Indian chapter. She has also contributed to Maharashtra Cyber and Bombay Management Association in an advisory role. And we also have Mr. Ajay Bhayani, who is our moderator for today. He is Director Security at AmbiSure Technologies, who will be delivering this power-packed fireside chat. By the way, to introduce myself, my name is Iqbal Qureshi, as you all might be knowing. I'm from CXO Junction. So talking about CXO Junction, so CXO Junction is a community for enterprise leader to come and discuss the evolving scene of cybersecurity and risk management. So in order to facilitate these kinds of discussion, we partner with multiple subject matter expert. Likewise, today we have partnered with AmbiSure Technologies for this amazing fireside chat. So talking about AmbiSure Technologies, so AmbiSure Technology is a privately held firm specializing in cybersecurity. They are on mission to deliver next generation cybersecurity solution and services which align with the business goal and comply with industry standards. Their IT security solution offerings includes threat prevention solution, threat detection and management solution, business enablement solution. They also work closely with companies offering IT infra to extend cutting-edge security solution for enterprises, consumers, government, and e-commerce companies. So stay tuned till the end. Now I would like to hand over the stage to Mr. Ajay Bhayani to take this forward. Over to you, Mr. Ajay.
Thank you, and great to see you, everyone, today, early morning, for this session. Thanks a lot, everyone, for joining in, and thanks a lot, Iqbal, for handing me the baton once again to do the tough job. And really excited to discuss on something which is really very recent. We have been planning this from quite some time, and the dates was fixed. And at that time only, the government decided to table the bill in Lok Sabha, which is now called Digital Personal Data Protection Bill 2023. And for that, we have Khushbu Jain, who is quite a good known name in the field of cybersecurity and financial crimes. She has been a practicing advocate before Supreme Court of India. And I would like to invite her. Khushbu, looking forward to see you here. You can start your camera.
Thank you. Thank you so much.
Great. So great to see you here. And it's a long time we have spoken. But yes, none other than the best time to speak on this on the DPDP 23. And we have known like privacy has been a really important concern so far, right? Now the idea out here is that the difference between the privacy and security, we all know, right? Privacy is all talking about how we are going to use the data, right? The right of information, the right of deletion, a lot of things. The definitions are well known. So instead of talking on like what is privacy, what should be there in the privacy bills, the idea of today's discussion, what we are going to have out here is that how are we going to implement if this particular bill gets passed with or without any modifications, and the day it becomes an act and a law, right? What should be the thought process for the companies? Because then will be implemented and it will be focused on each and every organization in the country, right? So how are we going to do it? So before we get into more detailed discussion, Khushbu, out here, what I want to really understand is that if you can give your major highlights of this bill, what is it trying to achieve through this? What are we looking at?
All right. So the basic 5 principles of information, that is, consent, explicit consent, when you talk about the mode of processing, then element deletion, security. These are the aspects which are very well covered in the data protection, the new data protection bill. And if I may quote it, that clearly speaks about how if you, let's say you're collecting somebody's data, are you taking their consent? That's the first process. The second that comes is after you take the consent, is it related to, is it clear? Is it very clear to the person from whom you're getting the consent? Does he understand that? That's the internal part of it. The second that comes is, are you using it, the purpose? Are you using it for the purpose you have taken the consent from? Because what happens is you do take a consent that I've taken data from you. When I say I've taken data from you, let's say you allow me for a contact list of yours. I'm an app, let's say for providing telemedicine or providing delivery of, of, uh, uh, of let's say, providing you, medicines at your home. Now with that app, I get into your contact list, but your whole purpose of coming to me, the whole purpose of coming to me was getting medicines delivered, and for that you given consent to me.
Right.
So what happens here is you cannot use my contact list for any other purpose for which I have given you a consent. Earlier, this never used to happen. You give your consent, the cookies and everything. They used to utilize that thing for other purposes. The second would be, the second here, the same place, that would be that, let's say I have given you a consent for using it for some purposes. And after that, I feel after some time that, no, I do not want to continue with the same. I want to take back my consent. So here also a user or a data principal, that is, us, whose data has been utilized, who's a subject, he has an option or he has a right to ask the data fiduciary to delete the data or to erase the data. The fourth would be that there are a lot of places where my data is incorrect.
Okay.
It's on a wrong information that the data has been processed or is being continued. So I have a right to correction now. I can request the data fiduciary that so and so data of mine, please amend or correct or alter it, or modify it. So right of modification, erasure, or, checking, asking the data fiduciary that what exactly is my data with you. So these are the amazing rights which you have. After that, the other right that comes is other aspect that comes is the security aspect. Fine, you need data to process it. You might give permission, take permission from, data principal for processing a data for whatever purposes. It can be for 20 more purposes if you define and, take the consent very clearly. Apart from, adding to that also, they are saying that you need to, now you do this, but you need to keep security in place because security is an important aspect. So these are all the basic principles which are there of information and which are being incorporated. This was there in APJ Shah committee, which was being given then. It was being discussed in the K. Puttaswamy judgment as well. And these are the basic 9 principles being there to 5, 9, keep going up and down. So I think these are the basic things that the whole act is on the basis of covering these 5 principles, which is a very good thing when you talk about users and also for the industry, because industry will now understand that what exactly are the legal contours which they have to confine themselves with.
So that's a great part, right? That today now we have something which is coming in that will really make some value of our data in place, and that gives us a responsibility that the way our data is going to be used, right? The responsibility and the the responsibility and the the baton has come to the end of the in the hand of the end user, that how he is going to allow the data to be used. The data was a concern earlier, but it was never taken seriously, right? The way it was being used, the way it was being processed. And yes, we have seen, cases in the past where the way the social media has used the data, the way, during the election commissions in the international countries, the data was being used and to influence the people. But now let's come to the implementation part of it, right? There are a lot of large companies and enterprise companies, a lot of small companies are collecting a lot of data from the users. Now, when we consider data, we are only talking about the PII or a PCI data or the financial data. What kind of data? What is the definition of the digital data we are looking at right now?
So we are looking at all kinds of data. It's a personally identifiable data, and that has no definition. They have gone away with something like, categorizing the information which can be recognized, personally been identified, is the information. So that's another thing, that there is no category of data now that, this is sensitive information, or this is critical information, and this is a normal personal information, and that's how, things were being taken care of. Now it is like it's a data, and a data which can be personally identified as a data. Hence, it is up to you with the kind of repercussions the data can come up. You keep that level of security. The liberty is being given to the companies.
Okay. Perfect. So I think so the definition of data is not there, but anything which
No, it is there. It's everything which is there, which is digitally being there with you, which is personally identifiable to a person, to an
Okay.
individual, to a user, or data principal is a information, PII.
Anything which can be referenced to me as a personal information is considered
absolutely.
as the personal data protection comes under this bill. Now,
Absolutely.
so that's a pretty vast and expansive definition for the data. So when we look at the implementing the same in the large organizations, what do you feel that who should be responsible for implementing it? Is it either the CIO or a CDO, chief digital officer, or a CISO or a legal officer? Who should be made responsible to understand and help organization to really implement this particular bill in the organizations?
See, it can be a combination of people. It depends on the structure of the company. If it's a significant data fiduciary or it's a normal data fiduciary, it also depends on that also, because if you're a significant data fiduciary, you need to have a data protection officer to, comply with certain things and, represent. But at the same time, see, ideal would be a combination of a CISO, CTO and a legal, so that one understands the compliance. At the same time, one understands the technology, and that's where the confluence happens. So I think it can be a combination of both, depending on what kind of authority you are. But I think you cannot miss any one of them. You need to have both. A person who either has knowledge of both, or a combination of two people, two departments coming together and coming in, because now this is going to go big. This is not going to be small. Earlier we used to just go away with, even if some breaches happened, if something happens, no knowledge doesn't matter, it did not had any impact. But now, even if you keep quiet, you think that there is a breach that has happened and you keep quiet, that also doesn't suffice. If you don't keep basic security standards in place, that also doesn't suffice. That itself is a penalty clause in the act. Apart from that, if you keep quiet, the way data revolves and the way things are, and with the help of dark web, it will be clearly being visible somewhere else, and you're like, oh, the breach has happened, and you kept quiet. That means it was a deliberate thing from you. Now you have a penalty. So whether the fault is there or not, just by hiding it, having a knowledge about it, that itself entails a penalty on you. So today is not the time where you can keep quiet. And I think government understood, everybody understood that how data is important, as you were rightly saying in the start of your discussion, that data plays a very important role now. And we understood it's not just for benefits of the company who are data rich, but also if data gets into a wrong hand, how it can have an impact on a country, one, how it can have an impact on security of individuals like you and me. Cybersecurity I'm talking about, because 90% of the crimes happen, or they go very smooth, because the cyber criminal is having access to your data. I'll give one very small example, may not link it directly, but that's an amazing way to understand that how data can have an important role, because now also people do like it, but they understand that it will be on the subject of surveillance. People are somebody's gonna see what I'm doing. No, the data stealing is not just the part that somebody's going to follow you or see you or do something. But if your data is gone, the repercussions are very high. I'll just give one small example of it. Let's say, Ajay, you get a call, and you get a call from, let's say, a bank, and the bank, XYZ bank, says, sir, I'm calling from bank, and you have got your credit limit is increased, and at the same time, we are providing you some coupons with respect to hotel stays. So you were like, that's an enticing thing, because personally you like staying, you travel a lot. So you do need coupons when it comes to stay. And at the same time, credit limit increase, because a lot of times your expenses are very high. So you say, okay, but what I have to do? So he's like, you have to do this. So you are like, how do I believe you're calling from my bank? So I'll be like, Ajay, your last credit card bill was 7,051 rupees. You're like, okay, the credit card bill before that of yours was this much. And you have opened your bank, let's say your birth date, I can tell you, or something else I can tell you, which is with the bank. Now, will you believe that I'm calling bank?
Of course. I mean, see, there's so much of data which is available. I mean, if it's getting
No,
breached,
but the aspect of believing becomes more, right?
more,
Now,
yeah,
let's, you still don't believe, having a knowledge that a lot of people call you. So you're
but,
like, ma'am, which branch are you calling from? So I say, I'm calling from Andheri, so and so bank from Andheri branch. Ma'am, what's your name? I say this, ma'am, can you give me a call in 10 minutes? I'm getting something urgent. The person gives a call. All right, sir, I'll give you a call in 10 minutes. Now, what you do is you go on Google and you search the bank, with the branch, and then you call up over there and you say, can you connect me with Khushbu? So they connect.
Yeah.
Then you are all trusted, right?
Then you're of course
How,
interested.
yeah. So how I've baited you is I have given the offer which are favorable to you because they're enticing. So I had a knowledge that you travel a lot, or you stay, you do a lot of bookings when it comes to hotels or 5 stars. So I've given you that so that you're already a little bit into that gullible part. The second, when you had a doubt, I had knowledge about your details as to your last credit card bills and stuffs, and little more personal detail of yours to make you believe that you think, okay, these are the information which a bank official can only get it, nobody else. The third level that comes is, even after that you had a doubt, you made sure that you call up, and that's where I played a little bit of cybercrime. That's where the loophole is, that I paid to the Google ad and come in the top at that time, because it's not just Ajay. I'm calling, my entire team is calling maybe thousands of Ajays at that time. So
Right.
that becomes much easier for us to do it. So that's how you do it. So data plays a very important role, because even if you become very smart, and as I think you, me, everybody are been saying repeatedly,
No,
humans are the weakest
in fact,
links
there
when
have
it
been
comes to
a lot of
security.
cases. In fact, there have been a lot of cases where the cyber security experts have also been duped. It's been in the news that they have been duped. They have been frauded for any kind of invoice scams or Paytm scams and all. And the beauty of this bill is that the timing of this is so correct, because today the certain talks about the 6-hour breach notification the moment you come to know. And if you're not doing it, and tomorrow after, let's say, 15 days or 20 days, the things start coming in the dark web, and if it comes into the media knowledge, you are in practically a soup. So it's helping in a way, if we look at from a very, very positive side, that the bill is enforcing us to become more proactive towards the security, plus the way we are going to use the data. Right? So now the concern which really comes is that who would be the right person in the organization or in the industry who should be approached to help implement these requirements of this bill? Because see, please understand one thing, that whosoever we say, the CIO, CTO, CDO, creating a community, committee in the organization to really help, but there needs to be certain industry experts who should be really be approached, who should be available to help you implement and understand this bill from the business aspect of that particular organization. You cannot implement this bill just because the bill says that you have to do so things, right? And you cannot just implement it blindly. It has to be in line with the business requirements, the way the business is going to utilize the data. So who should be the right person according to you in the industry? Should we really approach the big fours? Should we really approach the legal officers who really understand the law aspects of it? Should we really approach, the cybersecurity and the privacy consultants? Who should be the right, or should we keep any kind of criteria that the person who is going to be responsible to help me implement DPDP3, okay, 23 in my organization should have so and so capabilities? What should be there? Because privacy has never been a criteria in our country, right? So it's pretty new. I mean, of course, GDPR has been there, but should we approach a GDPR expert to do this? The question comes here.
No, you need to have somebody who understands the digital data protection bill, and if it comes into the act, that's where you need somebody who has a grasp over the intricacies of the language which has been put in over here, so that it translates into your business, it translates into your software. Because as if you look into the bill, it clearly talks about withdrawal, it talks about modifications of the data. These are the things which cannot be done later stage, and it becomes very expensive. That's where you need somebody who is there who sits and who's part of your system, who understands the law and can translate into your business and how the data should flow in your business. And there should be an aspect where the modification, that deletion, that alteration can be done at a in a smooth manner without having an added cost or a aspect where it cannot be implemented smoothly. So I think the person, it can be anybody who understands, who has a grasp over the subject, which is the data protection, digital data protection bill very clearly, and at the same time somebody who understands your business. As rightly said by you, that the bill is very open. Bill is not talking about industry specific standards to be put in. NIST does talk about guidelines when it comes to industry specific, and I have been vocal about industry specific standards to come in place, but the bill is open and transparent about that. That's where I think the game would come, that you need somebody who understands the industry, because how much data you're collecting, how that data has been flowing in your industry or your the entire process of your company. That's where you need somebody who understands the bill, who understands the intricacies of the bill, the compliance aspect of it, and at the same time who understands the type of business, like for example an e-commerce platform or a health tech company, or at the same time a company who's into automobile, or a normal news channel platform. Everybody would be different when it comes to kind of data that would come in, and kind of security standards they have to keep in place, because they have to understand. Or let's say fintech will have a different connotations to play, because RBI comes in play, SEBI has a role. When it comes to insurance, IRDI has its own rules and regulations. So I think it has to be a combination of people, as I said, or somebody who understands both the things. You need somebody who has a knowledge about it. Cannot be a GDPR person, because it's not identical to what GDPR says. It's different, and one has to have a grasp over, because one fault here and there and your entire process will go in drain. One. The second, which the other question of yours, which was on the aspect that who should be the second. So this is a pre-part of it. You should also think of somebody who understands this to be kept, who should not be part of your CISO, because see, your CISO and your CTO and CIO community would be the one who would be implementing the security. In case tomorrow something happens, as you said, that it can be a security expert whose fault. Sometimes humans are the weakest links, or it can be somebody else in your own system in the business. So you need to have a data protection officer, or a person who understands the who is part of the implementation. It can be a law firm, it can be a big four, so that in case something happens, you can have that person also have been part of it as an independent person to look into it. Apart from this, there can be an aspect where whenever the breach happens, what kind of notice has to go out, what kind of information has to go out, how much time. Like for example, certain says 6 hours, SEBI says something else, RBI says something else. What information should go to whom? Whether you are, apart from giving in information to the authority, do you have to give information to users? What kind of information you have to give users?
Exactly.
All these things have to be kept ready, because trust me, reputation loss is bigger than anything else. Till now, we have been looking into reputation loss only, and it would be bigger. Let's say, a good credit card company or something, and data has been breached. You would not want to be part of that company again. So reputation plays a very important role when it comes to breaches, and coming with the next level of breaches and penalties that would come. So you need to have somebody who has complete grasp over this subject, and I think that's another vertical or an unit you have to be appointed in your company, depending on the size and the kind of company you are.
Complete grasp on the subject. I mean, I think, see, the challenge is that the bill is still very new. It's still not become the law. I'm sure the government is going to give us enough time to help us implement. Absolutely, that would be there. But when we say that the person needs to have a complete grasp, and it's very much different from the GDPR and other privacy courses which people have been doing. There was a lot of trend the day the discussion around the bill started. Not recent in 2023, but the day it was being talked about that privacy is going to bear. It was initially PDP, and a lot of changes kept on happening. The privacy has been a pretty much bird, and there were a lot of courses which were happening. Everybody were trying to learn a lot of it, but when it's we are going to look at as a law, or it's going to come as a bill, right? The point is that are we looking at some from the any kind of initiative from the government that they are going to authorize people to make experts the way in cybersecurity, when we want to go for certain audits, you need to have a certain empaneled guy to really do an audit in a regulated environments, right? Are we looking at something like that in the privacy framework or in this bill aspect? Are we looking at it, or still things have not been discussed so far?
See, when you talk about data protection officer, the DPA, he'll be the one who can be anybody who has a knowledge about it. It cannot, there is no such requirement right now. But when you talk about the auditors, the data protection auditors, they need to be registered. So if I may quote the specific sections which is part of the current bill, it specifically talks about that you need to appoint an independent auditor to carry out data audit who shall evaluate compliance of your company in accordance with the provision of the act, and they keep on doing the three things, which is periodic audit measures, and also talk about can look into the impact of the assessment, which should be in the process as per the defined guidelines. But at the same time, when you talk about data protection officer, the only requirement we have is he should be the Indian citizen, one. The second that comes is he should represent the company, and at the third would be that he'll be responsible to the board of the company, and at the same time the governing body of that company. So he'll be the one who will be representing the entire board and responsible for the board for specifically purpose with respect to the data. So with the significant data fiduciary, it's a compulsory that you need to have a data protection officer in place. But with other companies, it's an optional thing for you, whether you want to have it or not. And these are the three basic requirements. Somebody has even asked the question about what are the qualifications of a DPO. Right now, there are no qualifications of a DPO or any of such part. Yeah, but it's a related question, so I'm just answering it right now, that we don't have any such thing. People are coming up with some certifications in the past also, whenever the bill was being put up, that people have come with some certifications. More the certifications, good for you, because you understand the subject more, but a certification is not the criteria for you to be a DPO right now. You can be a DPO if you have a grasp in subject, but one has to understand you have to be responsible, and you will be responsible. You will have some repercussions coming up in the future on that aspect. So that's where it is. And if something comes up in the future, because a lot of notifications have to come up after this also, which government has to notify, like for example, the aspect where you're talking about the time. So that time is also where government will notify that how much time.
The current the law or the act which has been put for in Lok Sabha, it doesn't talk about any kind of a timeline.
No, it says it has to be notified by the central government as whenever the case may be. So let's say it get passed, and the moment it gets the assent of the president, it's where after that they will issue a certificate, a notification that this will be applicable in 6 months, this will be applicable in a year or 2 months. There would be certain time that would be given to the industries to implement. But the best part about it is, because we don't have any industry specific, or they have not given us any standards to comply with, practically it's open for companies how to do it. So it's literally a less time, and half of the companies are already complying. Like I said, RBI, the companies which come under RBI, they have already complied with things, and same is with SEBI, and same is with IRDI, they have come up. So but yeah, there are large pool, like for example, e-commerce and others which have to, or health tech and others. So that's on you as to how you have to implement those standards and what level of standards. The only criteria is breach and basic audit. If you're not been caught, you are looking into 250 crores of a penalty. Up to.
We'll come to the penalties. I think that's on my agenda, and we still have some time on that. But before we do that, I mean, they rightly pointed out, see, the large companies, the regulated companies, they have enough framework, considering the SEBI, RBI, IRDA, they have been following security standards, and till certain extent, they are following the matters of privacy. But considering, the other companies which doesn't come under the regulatory gambit, right? Or there is no mandate from the regulation or from the law that, you need to really, the way you have to really handle your data, right? The concerns come there, right? How do they start preparing to handle the privacy related matters? Plus, when I say privacy related matters, because see, once this particular bill comes into picture, of course, there will be a lot of individuals who are practically quite aware and responsible the way, and they are not happy the way their data is being utilized. There will be tons of queries which will be coming in. So what preparations an organization should be doing so that they start handling this kind of queries, or this complaints will directly go to, I think the bill talks about creation of the board, data protection board. And so will the complaints directly go to the board, or it will be coming to the organization? What kind of reception an organization should really prepare so that they can handle such kind of privacy related queries or complaints?
A very valid question. So this starts with, again, have a person who deals with this, a dedicated person, or the vertical who deals with these things. One. Second, prepare prior only. The way you do fire drill now, you have to do a drill of, this also, that in case of something happens, scenario A, scenario, the level of reach that can happen and level of data that has gone, what kind of replies have to be given. So those standard replies can be prepared right now and can be kept in place so that if something happens, you have a very limited time. One is you have to understand the kind of breach that has happened and the impact, and take care of that specific system and area, and how to do at the same time look into the aspect of preserving that evidence in place, because now you just can't think of, okay, let go of it. Then also comes whether to pay ransom, not pay in crypto, not in crypto, criminal activity to pay in crypto. So all that thing you will be striving, and at the time of attack, it would be too many things to look into. So why not have things priorly been put in place when it comes to what kind of breaches, if something like that happens, what kind of reply has to go, who will be the responsible person, have that dedicated, that if this happens, this will be the responsible person. What are the replies? So standards reply can be put in so that, the basics which happened at that time can be put in at that time and can be sent it. You have to also understand what kind of laws are applicable on you, whether SEBI is applicable, IRDI is applicable, different jurisdictions also you have to look into, because the kind of way we might be in India, we might be in GDPR, we might be in European, or we might be somewhere else. So what kind of things you have to keep in place, and what all regulators you have to, notify or intimate at the same time, what kind of notices should go to people. This is when it comes to breach. The second that comes is there would be tons and tons and tons of information, questions that would come from users.
Just a second. Sorry, I'm stopping you here. And you came out with a point which I really didn't thought that we'll be discussing this point. But you spoke about that, the data, if you are in the European region and if you are in the other regions. So does this bill extend of the usage of data outside the Indian region? So let's say if my data is being used or being processed in the European region, so does this bill give the authority to the user the way GDPR does, that if there is any kind of a European Union citizen coming to an Indian region, still the GDPR is applicable? So does this bill talk about that also outside the Indian boundaries?
Absolutely, it does talk about that. The same way we had Cyber Act also applicable to every individual outside also, and it was not restricted. It is applicable to everything which is happening outside. That's where we let go of the aspect of the localization. So there's no more localization, which we were fighting from past 6 years. Everybody was talking about localization. We have gone away with the concept of localization. It's an open, wherever the company blacklist, country blacklist a country, that's where you can't share your data. Any country which is not blacklisted, you're open to have your own kind of contracts and negotiations and terms and conditions in your contract where you can share your data and put your data in other countries. And if something happens, it's not them, but it's you. So whenever you have to understand, it's a data fiduciary who will be responsible. So for me, if let's say data fiduciary is you, the point of contact is you, where my data has been taken, and after that you share your data with A, B, C, D. After that, that's say you put your data in, let's say, data center in Singapore or some other country. It's you who's liable for it, and that's where the burden goes from. You can transfer your burden looking into your contractual terms. What happens there? So I think that's another thing which you have to keep in mind, that you need to have a a person who understands data protection bill very well, to also amend all your contracts with your third party right now, so that there is an element of what liabilities, what indemnity you have to put in place, what kind of insurance you force the other companies to keep in place. Because if, let's say, a penalty comes tomorrow and the other third party, who's the one who, your liability shifts, let's say I sue you and your liability shifts to the third party, if he's not capable, it's not capable to pay that much of amount, you can do nothing except the insolvency or of that company. That's where you have to play a very important role, that the quantum of punishment that can occur or quantum of loss that can occur because of any mishap, that is being covered under the cyber insurance, and you make sure that that kind of cyber insurance is taken by the third party on your data, which comes on you. So I think a lot has to be done when it comes to replying to the authority, or notices to be given to the different level of authority in different jurisdiction, including India. And at the same time, third party contracts, what has to be done. And the third that comes is users, because there would be users who will be giving you enough and more of queries right now. What is my data with you? I need to correct, I need to modify, I want to erase. This data has been, leaked by your end. So you have to reply what kind of response has to go, whether it has been leaked or not. Let's say some information comes out tomorrow that your data has been breached.
See, these are the pointers which you're talking about if the data gets leaked today. But
I'm saying before. The other 2 points were before. Before, see what happens is, let's say there's no data breach, but you have to keep preparation has to be there, right? The preparation of the aspect that if tomorrow something happens, today you cannot tomorrow go and amend your contract.
I'm not talking about that. I'm talking about that there have been tons of data breaches happened. We have banks who have.
That is not applicable. That is not applicable. This is not a risk.
If there is a complaint which is coming in, then I have to also find it out that this data which has been being used
was earlier breached.
Was it earlier or was it new? Because what happens, the data keeps on getting breached again and again. That duplicacy in the dark web keeps on happening, right?
So the burden of proof is on data fiduciary. That's where I think all your officers, including CISOs and legal, if you have, will be because the whole liability or the burden of proof is on you. The burden of proof of showing that I kept the basic security standards in place, I have audits in place, and the third that comes is this data has not been this breach is not a result of this, or whatever the mishap has happened is not because of the breach which has happened at my end, but this is the earlier, because this data dump is already out, from so and so date, from this. And I think that's something, a benefit each and every company might take it, because the way our data is already out. So,
already breached, so don't worry about
it. A lot of it. So I think one wonderful place is everybody can go, and I think a lot of people must already be knowing also. I'll put it in the box. That's, you can go to Have I Been Pawned?
That's right.
Yeah, I think everybody has already been seen that, but still it's a good one to keep checking yourself. Have I been pawned? PAWNED. Check your phone number, check your email address right over there. You can even check your passwords. You can put your URLs to check things in and around that if something has happened, and keep checking yourself, because that's again very important. Somebody has also put in questions with regard to if my data has been breached, how do I look and what not. I think this is one of the best places you can keep looking yourself, so that there is nobody impersonating you on internet and cheating somebody else using your name. And also, if you get to know if your password has been breached or some data is already out, you can go and make changes about it.
Perfect. Okay, very quickly now let's talk about the penalties. I mean, that is something which is we can talk about the securing the data, privacy of the data and everything, but let's understand that you are definitely going to get breached, somewhat may, right? Now, what are the criterias? I mean, the bill talks about up to 250 crores.
250 crores, yes.
Right? It talks about up to 250 crores of penalties. Now, what criterias are being considered to come up to that amount of queries? Is the turnover of the company is being considered? Is the amount of data being leaked is being considered? What are the criterias? Is there any kind of a definition of those criterias that okay, agar ek entry delete hua ya expose hua hai, then it will be this is amount of data or this is amount of penalty you're looking at, or if it's like so much of data being so, what are the criterias out there?
Okay, so let's start with there are certain duties which have been put into. So if you violate that user's duty, then you have up to 10,000 rupees that can be put in by us users. Okay, then let's say there is a voluntary undertaking you have given to the board, and in that there is a breach of any of the terms and conditions of your voluntary undertaking being given to the board, the data protection board. So then it can be it can extend up to the kind of entity which has been part of it, or how the thing is, and it is on the board to decide. For any other breaches, it can be up to 50 crores. Now comes the important aspect that comes is, let's say you fail to take reasonable security safeguards to prevent personal data breach. Basic reasonable security standards, which even SDPI rules talked about. So in failure to take that reasonable security safeguard to prevent a personal data of a user and that breach happens, that's up to 250 crores. The second is, let's say a breach has happened. Now you fail to notify the board. This is where I was talking about, or you fail to notify the affected data principals. Let's say my data has been breached at your end and you don't tell me about it. And you sit silently, which we were doing it till now. So even let's say it's your fault, no fault, whether you have maintained the reasonable security, you might have let go of that aspect of penalty on you because you say, boss, I have maintained the reasonable security. Cyber attacks are here to stay. I can't do anything now. So, you can let go of the penalty aspect on you. But no, you were sitting silent. In that scenario, sitting silent itself brings you up to 200 crores of a penalty. So, sitting idle or, hiding doesn't. It's not a question now.
Not a question now.
Let's say non-fulfillment of obligations in relation to processing of a data of children.
So that's a complete no.
That's a non-fulfillment of there are certain obligations when you take children data, like you have to take consent from the parents, what kind of data you can process and what kind of things, these have been defined over there. Let's say you don't comply with that. In that scenario, you have a fine up to 200 crores. Then let's say non-fulfillment of obligations of significant data fiduciary. So when I say, let's say the significant data fiduciary whose definition has been given doesn't appoint a data protection officer or doesn't do certain things which it has been asked in the bill to do, that non-fulfillment on a significant data fiduciary itself is up to 150 crores. So there are some 6-7 different types of penalties which can be, and they have to again look into the details when you say non-fulfillment of obligation in processing of children. So you have to look into with children what all the obligations data fiduciary has to keep in place. So those have to be put into a compartment and do it, and in failure to do so, up to this. So maybe, have that kind of chart in place if you're in business, will help you out to navigate.
Okay.
To understand
about this, the compliance around the data, and when you talked about the reasonable measures taken to take care of the privacy in the organization. When we talk about the large organizations, again, it's pretty much possible. I mean, I'm not seeing much of an hurdle to really do it. But when we come to a mid-size and a small-size organizations, now, can we have like a 10-pointer commandment? Okay, if you do this 10 things, you are reasonably secure, right? Or you are reasonably compliant, and that's one part. The second part is that when we talk about the penalties, we are talking about in crores, like we're talking about 100 crores, 200 crores, 250 crores. But when we look at these mid-size and these small-size organizations, is the penalty amounts being looked at the same time? Because see, the data is being collected to the local grocery shop se leke, local SIM card guys also, right? So of course, the data is going to be utilized there as well, right? As an informed citizen, I'm definitely going to make an effort that, to make sure, tell them that, okay, don't do it. But let's say I come to know tomorrow that, okay, I had given a data here and this is the data which is being misutilized. So, and if I make a complaint, will that data or the penalty is going to be up to that amount of crores? And, what this small size or mid-size organizations really do.
Okay. So what exactly the mid-size and small-size companies should do, I'll come the second. The first question of yours is a direct answer. So when you talk about the penalty or the quantum of penalty, let's say something happens, some mishap happens, the board can determine the quantum of financial penalty as long as you adhere to, the kind of things are being given, and they will even quantify on the following factors if you look into, and the factors can be the nature, the gravity, and the duration of the breach. Let's say the breach is very, it was just fraction of seconds and you have amended. So they look into this for quantifying the penalty it can impose on you. The second is the type and the nature of personal data affected by the breach. That's why I was talking about it is you now who has to compartmentalize data with the kind of data you take, with the kind of company you are, that you make things security standards as per this. Okay, this has to be utmost security, this has to be this has to be that. Then comes is repetitive nature of breach. Let's say, you don't follow anything. That also plays an important role on, how much penalty it can be imposed on you. Then whether a person as a result of breach has realized a gain or avoided any kind of loss. So gain or a loss is any kind of property gain or any kind of gain you have had, which in a normal course of business, you would have not got it, but you have added to that. And because of that, you have got more gain, or there's a loss that has happened, or whether a person who took any action to mitigate that effect. Let's say some breach has happened and you're sitting silent, you do nothing on it. So that will entail a higher penalty. But if you, let's say you have put in some measures in place and you have taken some actions to mitigate that, the effect of the breach that has happened, or the consequences of the breach that have happened, and what are the effectiveness of the such actions that you have taken, that will also determine the quantum of penalty that would be imposed on you by the board. The other one would be whether the financial penalties to be imposed is proportionate and effective, having regard to the need of secure observance of and deter breach of provisions of the act. So that if you have kept in place, it should be like, for example, the breach has no impact per se. So that will have a direct connotation on the other thing. And also you have to understand it will impact a financial penalty on the person. So that will also, will have an impact. So let's say because of your breach, there is a person who has lost a lot of money because of your breach. So what kind of impact that would come on you will be determined. So
Okay.
so somebody's asking a very good question, which I'm tempted to answer.
Right, so
Can I use
definitely,
data?
I'll go ahead and start asking, because there's a lot of questions. There's too much to cover, and I think let's address the questions from the audience as well. We have Deval who is asking here, what are the provisions to compensate the data principals after collecting the penalties from data fiduciaries and or the processors? And that's a pretty good question out here.
I didn't get the question. Can you repeat it again? I'm so sorry.
So what are the provisions to compensate the data principals, the end users, after collecting the penalties from the data fiduciaries or the processors?
Oh, that's a very good question. So see, there are some ways where some amount will go directly to the consolidated fund. There are some where it will be look into the kind of damage that has come into. When I was talking about that 10,000 rupees, that up to 10,000 will come to you. Let's say some breach has happened directly. Let's say I've lost the money from my account because a lot of my data has been breached by you, which resulted into me losing that money from my account. So that whole amount will come to you. Apart from that, you can ask for damages. You can ask for the 10,000 rupees of a penalty that can be imposed. And at the same time, you can ask for the lawyer's fee and other fee. So it can be quantified in that manner. But whatever the loss has happened will come to you, provided you have been able to define or quantify the loss. But if it's a direct loss, let's say a breach has happened and I've lost the money, that money will be given to you. But rest of the things which are there as a penalty, that's a penalty that goes into Consolidated Fund of India, doesn't come to us. But the user specific penalties are there, which till now was never there. So the user can sue, and one can sue together also. So you, me, all of us together can be part of one application, which was never part of anything in India. So we can have 10,000 up to. So let's say there are a crore of people, and 10,000 rupees to each. Imagine the company has to end up paying, apart from 250 crores or whatever, up to 250 crores when it comes in place. So that's a way to play.
That's a beautiful aspect again of this bill, that the end user is definitely going to be compensated in some or other way. Up to 10,000 rupees is something which is fixed, but still, again, it depends on the nature of the breach, the nature of.
If you have lost the money, then you have lost the money because of that, and you can, directly take the.
That's so interesting. Thanks a lot for that question, Deval sir. Okay. There's one question which is coming up. Are government agencies handling personal data also become liable for the damages in the event of breach? For example, the Aadhaar data leaked via UIDAI? I think that's a pretty common question. And other data features have been talked about and discussed about, debated about in a lot of places. So I think let's answer that.
So there are a lot of exemptions being given in the bill, and the exemptions are given to the government for collecting of your data in terms of providing you subsidies and other things. And there are certain organizations like Medical Institute for the Research Purposes and others. So they are being exempted from the bill. They are not being liable on that aspect. But yeah.
Okay. So as of now,
I don't.
the government
Yeah,
agencies are out of it. It's more on the enterprise.
Next question. Next question.
Okay, how to handle the cases where the aggregator or the third party is collecting the data and sharing with us? It's about data aggregators we are talking about.
No, so data aggregator is the one who will be there would be a consent manager involved into it, right?
Okay.
So the consent manager is clearly been defined. Consent manager is the one who will be liable for all your, from the data principal side. I just have to tell the consent manager, "Ki boss, this data has to be modified, this data has to be deleted, this data has to be looked into. This is my absolute consent, or this is not my consent, or provide me details." And he'll be the one, and interoperability also. So he'll be the one who will be liable for everything in between when it comes to these two platforms.
Interesting. Okay.
These consent managers are the one who will be appointed by the board as and whenever they come with the definition and everything in that.
Okay.
So
But
you register your
after
be a
the
data
data
consent
protection board
manager.
comes into picture? That
Yeah. And you'll have to qualify and register yourself to be a consent manager.
Oh, interesting. Okay. Now, one of my banker friend is asking is, and because and I'm sure he's also pretty much pissed up with this, and we keep on getting a lot of calls from the from the credit card companies and all the stuff. A lot of cold calls are coming in right at the end of the day today. So the question is that considering we have been trying to register ourselves to do not disturb list and everything. So will this be avoided once the Privacy Act comes into play? Or will still the financial institute try and find out loopholes in it? Can we claim compensation in that if we can get some calls in future?
So let's say you get some call in the future. It depends whether it has converted into a loss or a gain. By getting a call, you need to be in a state to provide that data has been leaked and somebody else is calling on their behalf, and where the data has been leaked from. The burden of proof comes on the data fiduciary. But this is a good good situation, because you should be in a state to understand where the data has been breached and from where this call has coming from. For second, now with the bill comes in
we are not
place, when
talking
it
about the
comes
breach
in.
out here, Khushbu. So we are not talking about the breach out there. We are talking about there are a lot of cold calls coming in from the banking fraternity, from the credit card companies, and I'm not talking about against any industry right now. Please understand here. I'm talking about there are a lot of cold calls happening. And when we're talking about the compensations, we are not talking from the perspective that I have faced the loss. I really do not want to get the calls. I do not want.
They are, as it is, not allowed by TRI. They are as it is today. Also, you have a law which clearly talks about that you get into do not disturb, and if still the call comes, then is where they will block and take action against those. But not, I mean, I'm sorry to say,
there
but
is no relation with the privacy law as of now on that, right?
No, but it will in a way you can link it, because when I say that I'm giving you my information, let's say I'm giving a information to the bank for XYZ purposes only. They should not utilize it for any other purpose than XYZ.
Okay.
So when you sign those 20 pages, when you see, you should understand that what all things are you signing your details for. So you don't want to receive any kind of advertisements or any kind of calls with regard to credit cards or with regard to upgradations or anything. And you don't sign up for that and still you get it. That's where you can, let's say you go and buy a car and you start getting loans,
Right.
car loan details. So that's where I think when you consent, when you buy a car and you write it, you say that I don't want any ancillary products or cold calls or anything. When you don't consent for it, still you get it, you can sue the car company, because that's where you can relate that I've given you the data for specific purpose. And if you're not utilizing it for specific purposes, you are breaching one of the penalties, one of the clauses which are there in the data protection bill. Hence, you should be liable for the punishment, and punishment can go up to, if it's significant, it goes to 150, or if it's normal, it goes to 250. Sorry, it goes to 250.
Let's extend this a bit out here. Let's say if I receive, after the law comes into picture and I receive a cold call out here, okay, can I request the caller just verbally that as per the bill or as per the law, I do not want you to be calling me for or doing a cold calls for any kind of credit card or any kind of loan applications. Can I make that as a request to the company? Or should I have to make it a written approach? Because I really don't know. It's not the company who is calling. It's always the third parties who are calling.
Yeah, I was coming on that. It's
I really do not have that as a, there is no tracking from the bank to the third party calling company. Okay. Okay. You understand the whole infrastructure, right? The way the calls happen, right? So can, as an individual, I can do it anything like that? Or it's still not clear. There is no clarity around it.
See, there would be a clarity the moment the consent part comes very clearly. Let's say you have not consented for getting calls. And after that, if you get a call, what you can do is you can give a simple notice to, let's say, bank, because you don't know the third party. For you, that would be an XYZ bank or XYZ company who's calling you up, right? So you call up your XYZ bank or give them a basic notice under the standard which will be provided, which, whatever that they are now compulsory to provide you a 24/7 email address and a number. You can just write that I have received call from so-and-so number representing you.
Right.
I have not opted for any such things, would request you to.
So I think that
from the future. And if you again get it, maybe you can then go on and, write a complaint in Data Protection Authority. But at the same time, as you rightly said, it's by the third party. And sometimes it's not even a third party giving you a cold call. It would be a lot of other people trying to give you a call to dupe you into something. But yes, that's something which need to be addressed and which can be put in, because if you're not giving it for purpose of advertisements or getting calls or getting some more details, that's where you can just simply say that it's a clear no for my contact.
Perfect. I'll ask very last question and I'll hand over to Iqbal on this. We are just almost about the time. So is Rajendra Kathal is asking here, is imprisonment also provisioned as a part of, so let's say if company is not able to make the financial payments.
No. I'll stop here only. No imprisonment, only the financial penalty. The earlier bill which we had, which was just 2019 bill, had the talk about up to 7 years of imprisonment. But now we don't have, we have just come up with the penalties. And there would be other things which will be covered in the Cyber Act and others, doing something fraudulent act or something. But directly attack that has happened or things which have happened will not get into a part of imprisonment. There is no such things in the present bill. Only the financial penalties, which is up to 150, 250 and 10,000, depending on the criteria.
Perfect. Thanks a lot for that. And thanks a lot, Khushbu, for this interesting discussion. I do have a lot of questions to ask you, but I think we can take it up sometime later on. And I think we need to have such kind of more discussions coming up. But just to give you a brief understanding of what I take, the takeoff of me from this particular discussion is that one thing is for any kind of a company, may be a large, medium or small size, the data from today, what they are going to collect, or from the day the law comes into picture, they really need to make sure that, what kind of data and how are they going to utilize, and they need to really keep on advocating and confirming the way that they are going to utilize the data. So you really need to focus on that. Plus, they need to have reasonable efforts to be taken care of the way they are going to utilize the data. So whenever the complaints or anything which comes to them, they should be able to demonstrate the reasonable amount of security being used to protect the data, the way they are going to use the data. They have to have a processes irrespective of a large company or a smaller company. They need to have that. That is, again, one of the major takeaways from this bill. We definitely look forward that this bill comes out as a law. But yes, there are a lot of challenges. There is a lot of, clarity which would be required. And yes, it's still a pretty early to do a lot of commenting on that. And let's wait for it. We'll try and have such discussions again. Thanks a lot, Khushbu, for, giving an amazing insights. Our audience really enjoyed it. We have been live on LinkedIn as well. Please definitely look into that. There will be a lot of questions coming on that as well. And do take out time to answer on that. Or guys, if you have any other questions after this session, you can go on the LinkedIn live session and put a question on that as well. Right. Thanks a lot, Khushbu.
Thank you. I think somebody's asking for my LinkedIn link also. Even I don't know that. I'll just check and put it.
Okay, we'll put that out on the thing. Over
Thank
to
you.
you.
Okay, thank you so much, Ajay sir, Khushbu ma'am, for this insightful session. It is well said that knowledge is alone not a power, but sharing of knowledge is when the knowledge becomes powerful. And I think both our speaker today believes in this. Thank you so much once again for this in-depth knowledge. And I'm damn sure this 1 hour was very extremely well worth it of the time to all the audience.
Thank you. Thanks a lot, Iqbal. Thanks a lot, Khushbu.
Have a great afternoon.
Have a great
Thank
week.
you. Thank you so much.
You guys.
Bye-bye.